Hello, and welcome back. This is Dan, your helpful family law attorney in Southern California. Domestic violence restraining orders are such a complex and important field of family law. It'd be extremely difficult to cover even the general rules in my short videos. For this reason, I've decided to break up the topic of domestic violence restraining orders in California into multiple videos. If you've been keeping up with this video series, you may have identified that we covered a different type of restraining order in another video. In legal terms, restraining orders inhibit somebody's ability to perform an action they would normally and legally be allowed to do. While general restraining orders such as ATROS covered in my prior video may not have a negative implication in your family law case unless it's violated, the domestic violence restraining order has severe consequences that not only negatively impact your family law case, but also inhibit some of your constitutional rights. We will discuss the consequences of a domestic violence restraining order in a separate video. In this video, I would like to focus on the process of requesting and responding to a restraining order. To file a domestic violence restraining order, you and the person you want to restrain must be married or domestic partners, divorced or separated, dating or used to be dating, living together or used to be living together, parents of a child together, or closely related. Closely related would be generally if somebody was a member of your family. Following the incident that leads to the request for a domestic violence restraining order, the requested party is required to file a few forms that are listed on your screen. Once these documents are filed with the court will review the documents and determine whether there are grounds for a temporary restraining order until the court can hold a domestic violence restraining order trial. This decision is made within 24 to 48 hours and is similar to an ex parte application where the court can make a decision after only hearing from one party. Once the temporary order is issued or denied, the requesting party is required to get a copy of their documents and have the documents personally served on the responding party. A list of all the documents that need to be served on the responding party is listed on your DV-109 form. This form will also have the deadline for service. Generally, it's 5 days before the hearing, but the court can change that time. Service must be done by the County Sheriff's Department, a professional process server, or anyone who's 18 years or older not a party to the action. Once the responding party is served, he or she may file a response 2 court days prior to the hearing. If the responding party needs more time to prepare and gather documents, he or she may appear at the hearing and request a one-time continuance for 3 weeks. During this time, the temporary orders will continue to be in place. These are just general rules, and family law is a complex field. This information does not constitute legal advice, and if you have a family law case or question, please talk to a lawyer in your area. Thank you for watching. In the next video, we'll continue to discuss domestic violence restraining orders. Please like, comment, subscribe, and hit the bell button for notifications for all my future videos.